Hey everybody, Colin from Rod and Glazer and Schaefer. Hope you guys had a great week, sliding into the weekend with some awesome weather on tap. I don't know about you, but I'm pretty excited about it. Coming at you this week with a topic that we don't talk all that often about at OGS, but it does come up pretty often, and I think as attorneys, this is a question that we get all the time. So I've answered it like 1,000 times. It came up again this week. Thought I'd make a video about it. Before I get started though, I want to give a shout out to attorney Tom Burton. Tom is very active on LinkedIn. He makes awesome videos all about estate planning, and also does a segment where he answers client questions, obviously anonymously. I think that they're very informative, and if you're interested in taking a deep dive on this topic, I would hook up with Tom on LinkedIn and start watching his videos. I'm going to tag him in this post. So let's get started. The question I got was, what is the difference between what does the estate mean, and what is the difference between a probate and non-probate asset, and why does it matter? All right, great questions. I'm going to try to answer them quickly. So number one, what does the estate mean? When people on the street say estate, they usually mean every piece of property the person had when they died, right? So if somebody says, oh, Colin had a 401k worth $5 million and he had a $7 million house, he had a $12 million estate. Yeah. So in legal terms, that's not what estate means. Estate means all of the person's property that was subject to the probate process, right? So keep that in mind. All of the person's property that was subject to the probate process. That's the key designation, subject to the probate process. What is the probate process? Probate is the legal mechanism that we use to open someone's estate, wind up their affairs, and close it after they pass away, okay? So what is the difference between a non-probate and probate asset? If we know the estate includes all assets that are subject to probate, there must be some assets that are not subject to probate or are non-probate assets. Yeah, there are. Anything with a beneficiary designation is considered a non-probate asset. So for a lot of people, I'm just going to speak for myself here, that's our 401k. That's a bank account with a beneficiary designation or a payable on death designation. That's a house or another piece of another asset that you hold as a joint tenant with the right of survivorship. So for a lot of people in Wisconsin, married people in Wisconsin, that's your primary residence, usually held by husband and wife with right of survivorship. So conceptually, what a non-probate asset or a non-probate transfer counts as a lifetime gift. So it's as if someone gave it to you while they were still alive. So conceptually, it's like you're on your deathbed and you whisper, you can have my 401k. So the transfer has already happened, although, in real life, it happens after you pass away. But in the figment of our imagination in the legal world, that transfer technically is happening while that person is still alive for tax purposes, most notably. So anything with a beneficiary designation is not an estate asset and is not a probate asset, therefore, and is not subject to estate administration. So why does that matter? That's great cocktail knowledge. Now when somebody says, oh, his estate was $100 million, you could say, well, I don't know. If that 401k was $9 million, his estate was really only $1 million, maybe, right? But why does it matter? Well, it matters because in Wisconsin, if your estate assets are $50,000 or less, then you don't have to open a probate case in the circuit court in the county where the person passed away. You can transfer the remaining assets with what's called a transfer by affidavit, which is 2 pieces of paper versus a 6 to 12 month probate process.